geographical locations, my lords, I would not dispute, my lords. Hardly 4 or 5 kilometers. Well, I will not. My lord, I'll submit my submissions. If the Lorraine Senior Council is not able to come, lords, I'll explain. So as to how, my lords, the Mittal judgment, my lords, is no judgment as far as quantification is concerned. Because their lordships, please, please, not disputed, not disputed.
They, when they, my lord, they challenge this, my lord, ultimately under the KIDB, my lord, it is the state, my lord, which, my lord, acquires the land. So, my lord, even KIDB, my lord, cannot challenge. It is only the state, my lord, can challenge the order of the reference court. And your lordships are aware, my lord, thing where, my lord, it is said that the company, which is a subsequent beneficiary, my lord, they have no locus to challenge at all. So here, my lord, the Honorable Division Bench, my lord, in the judgment, the Honorable Division Bench, my lord, here what they do is, they go up there, KIDB goes there saying that our secretary was not made a party. So we were not given an opportunity. So they challenged the award made in ArcelorMittal case by the reference court. So, my lord, the Honorable Division Bench subsequently in the operative portion, so, my lord, remands the matter back to the reference court to consider everything that, my lord, the Honorable Supreme Court has very clearly said that the land acquisition officer was present. So, it is the state who has to challenge it, and they have no locus. So, my lord, the Supreme Court is, so ArcelorMittal judgment has become final. I'm informed, I may be subject to correction, or I may be wrong. It appears they have made a submission that it was not challenged by the beneficiary in that, my lord, but beneficiary either ways cannot challenge it. They cannot challenge the award passed by the order passed by the reference court. The beneficiary cannot challenge it at all. So it's only the state. Even KIDB also cannot challenge it. It's only the state, and the SLO is also of the state. Unlike in BDM, where they are on deputation to BDA. There also there was a contention taken that whether they have the powers, the BDA SLO. But here it is the state, so what ArcelorMittal, in ArcelorMittal, they have considered any potentiality, which has not been considered in the instant case before your lordship. Yes. Either. Apex court.
I have produced it along with the memo.
Here, if your lordship please. They have gone in detail. So it is not as though it is on some technicalities they have passed the order. The special land acquisition officer, who was admittedly an officer of the board, stepped into the witness box and he has given his evidence which has been considered.
Only judgment.
Sub-registers specialty don't those. Our case now, ಅದನ್ನ ಹೇಳಿದವರು ನಮ್ಮ case ನಾಗ ಅದು ಹೇಳ್ಬೇಕಾಗಿಲ್ಲ. My lords, the name is not forthcoming, my lords, in the 28(1) notification or 28(4) notification. My lords. My lords, we have participated in the GIM, the Global Investors Meet, my lords, and subsequent to that, my lord, the land acquisition has taken place. Brahmin is me.
Did you give proposal to the KDB saying that we need so much of land? And that proposal being processed by the KDB, acquisition process began.
Just instructions, I'll just take 1 minute.
That is exhibit P29, page 144. There also an MOU was entered on virtually the same date with ArcelorMittal as well as with Brahmini, who was earlier there. Then from there, it has been transferred to the present Uttam Galwa. So that MOU, my lord, is at page 144, exhibit P29. That is the MOU entered in. That is page 145 and 146 and 147. MOU, my lord. As you were saying, the global investors meet, what your lordships were asking.
No, that was also KDB acquisition.
Yes, both are KDB. My lord, both are KDB acquisition only. And
He said the beneficiary will be made a part of the beneficiary means from whom you take the money.
in ArcelorMittal also, agricultural SR value was taken and NA value was taken. The same thing we had also produced. Here, that has been taken in ArcelorMittal, the NA, looking at the potentiality, that my lord has been taken and they have awarded. And even in our thing also, my lord, different prizes have been awarded. And the same Kurtini village, of part of which lands have been acquired. My lord, there also earlier in ArcelorMittal, the award, my lord, had only 1.5 lakhs in lot. Subsequently, it was enhanced there in respect of that village. So, our also contention is, you know, rating system could be seen, because even in our thing they have reduced it. But there are, my lord, we have produced some 2-3 judgments, my lord, it has been placed on record today itself, my lord, which would say that if it is, and one is, my lord, if it is the same acquisition, there should not be discrimination.
How many thousands of farmers had given consent for award, consent award they had obtained?
Some 80%.
What is the total number, Budihal?
My lords, 88.8% of people, my lords, the
They
land.
will be about?
My lords,
How many?
Out of 4,958 acres, not 88%.
no.
Yes, accepted.
My lords, 4,284.98, my lords, out of 4,950 extent of acres, my lords.
So total extent required was how much?
My lords, 4,950,
ಎಲ್ಲಿ ಸಿಗ್ತದೆ ಇದರಲ್ಲಿ?
my lords.
ಎಲ್ಲಿ ಸಿಗ್ತದೆ ಇದರಲ್ಲಿ? Records ನಲ್ಲಿ ಎಲ್ಲಿದೆ? Number ಹೇಳಿ. Any indication in any of the orders? Any paper here?
28(1) and 28(4) would be, my lords, the total extent of land, my lords. 28(1) and 28(4), my lords, the
No,
notification.
ಅದೆಲ್ಲ ಇದ್ರಾಗ ಎಲ್ಲಿದೆ? Paper book ನಲ್ಲಿ ಎಲ್ಲಿದೆ?
That has not been,
Huh?
Not disputed.
no, that is not adverted, my lords. The submission has indeed been made, my lord. And yeah, I'm sure, my lord, my learned friend also would not dispute the fact that 88.88%, my lords, of the landowners have accepted the consent award, my lord.
The subject matter before your lordships is 288 acres.
288 acres.
Please.
Total extent ಎಷ್ಟು?
Plus total extent, my lords, is 4950.61 acres, my lord. No, namdu. My lord, in that 4950, my lords, 93 acres is a government land, my lords. So the total private land, my lords, would be 4857.61 acres, my lord.
48,
4857.61 acres, my lord, would be the total extent of private land acquired, my lord.
ಹಾ,
But to an extent of 20 acres, my lord, there has been a double entry, my lords.
ಇದರಲ್ಲೇ.
ಹೌದು ಸ್ವಾಮಿ.
So 4837 ಆಗ್ತದಾ?
4837, my lords. Out of which, my lord, total PAC fixed value, my lords, 4284.98 acres, my lord.
ಹಾ?
Total, four
Price advisory committee, my lords, has
consent award.
consent award.
ಕನ್ಸೆಂಟ್ ಅವಾರ್ಡ್ಗೆ ಎಷ್ಟು?
Consent award has been
ಇದು
accepted.
ಟೋಟಲ್ ಲ್ಯಾಂಡ್ 4837 acres plus 93 acres.
Please, my lord.
4837 plus 93 ನಾ?
4857 is private land, my lords, and 93 is
ಅದ್ರಲ್ಲಿ 20 ಡುಪ್ಲಿಕೇಶನ್ ಆಗಿದೆ.
duplication ಆಗಿದೆ ಸ್ವಾಮಿ.
20 ಹೋದ್ರೆ 4837.
Please, my lord. Please, my lord.
4837 plus 93.
Plus 93, my lord.
93 ಗವರ್ಮೆಂಟ್ ಲ್ಯಾಂಡ್ ಈ ಇಶ್ಯೂ ಹೇಳೋದಿಲ್ಲ.
Please, out of which, my lord, consent award has been accepted by the landowners of 4284.98 acres, my lord. And 4,284.98 acres, my lord.
85 acres.
4,000, please, rounded up.
4285 acres.
And the present appeal, my lords, the
ಕನ್ಸೆಂಟ್
batch of
ಅವಾರ್ಡ್ ಕಂಪೋಸಿಟ್ ಮನಿ ಎಷ್ಟು ಅದ್ರ? ಲಂಪ್ ಸಮ್.
it's different for different lands, my lord. I'll submit, my lord.
Three classes ಇದೆ ಏನಲ್ಲಿ?
Four classes, please,
Four
my lord,
classes.
depending upon the villages, my lord.
ಹಾ, ಈ ವಿಲೇಜಿಗೆ ಸಂಬಂಧಪಡೋದು ಇವ್ರ ಕೇಸಿಗೆ ಸಂಬಂಧಪಡೋದು ಎಷ್ಟು?
In fact, my lord,
ಇವ್ರದ್ದು ಬೇರೆ ಬೇರೆ ವಿಲೇಜಸ್ ಇದೆ.
different.
ಆಲ್ 4 ವಿಲೇಜಸ್ ಇದೆ.
Please,
All
my lord.
four villages are there in North India.
It is mixed up.
ಅದು
Kudthini village is
ಅಲ್ಲ
130 acres.
ಅರ್ಸೆಲ್
Lords, for Kolagallu village, my lord,
Huh?
8, for Kolagallu village, my lord, 8 lakhs per acre has been granted, my lords, by the PAC committee, my lord. Has been agreed.
ಸ್ಪೆಲ್ಲಿಂಗ್ spell.
KOLAGALLU, my lord, Kolagallu.
KOLA
GALLU, my lord.
ಕೊಲಗಲ್ಲು.
And belting systems they have followed, my lords, between the railway tracks and the national highway, my lords. So that is 8 lakhs per acre, my lord.
50. 15 ನಾ? Page number 9. 50. Page 50 ಅಲ್ಲಿ ಎಲ್ಲ ಇದೆ ನೋಡಿ, ಡೀಟೇಲ್ಸ್ ಎಲ್ಲ ಇದೆ.
Please.
ಕುಡುತಿನಿ ವೀರಾಪುರ ಹೌದಾ?
But could,
Land situated
ಕೊಳಗಲ್ಲು,
please, my lord. And Erangalli.
ಎರ್ರಂಗಲ್ಲಿ.
Erangalli, please, my lord.
ಹಾ. ಅದೇ ವೇಣಿ ವೀರಾಪುರ.
Not only though there are 4 villages, my lord, the classification has been made, my lords, as far as 3 is concerned, my lord. That's not village centric, my lord. It has been Kolagallu village, lands between railway tracks and National Highway 65, my lords. It is at 8 lakhs per acre, and 190.11 acres of land uh, has been subjected to consent award, my lord.
5 lakh, 6 lakh, 8 lakh ಇದೆ.
5 lakhs, 6 lakh, 8 lakhs, my lord.
5 lakhs, 6 lakhs and 8 lakhs. Belting system.
Understood. Why that 1 acre order, 25 lakhs ಇದೆಯಲ್ಲ?
Please, my lord.
Why it should not be acted upon?
Plus, P27 and P28, my lords, are the
That also, it was a KIDB acquisition.
illa, that they are private sale agreements. P27, P28, please, my lord.
Yes, sir. That factor
I just speak.
in
My
the
lord, the
KIDB.
sale deed which the P27, my lord, we will not for a moment, will not go on that because it was cash transaction and the court held that we cannot look into that. And even in ArcelorMittal, my lord, that particular, those exhibits have not been looked into. So once I rely on ArcelorMittal, I cannot rely on what is beneficial for me and what is not. So, my lord, to that extent, I will not go. That with regard to the sale deeds which have been produced, that exhibit P27 and 28, that will not, my lord,
Exhibits 27, 28, you will not press into service.
yes, that will not. We'll,
Independent of that, you want to argue the matter.
Lord, because NA potential.
Because
That is
of
one
NA
aspect of the
potential.
matter. NA potentiality is what, in fact, ArcelorMittal also, my lord, discards that those exhibits.
Okay.
Yes.
So to that extent, the reference judge is right.
Yes, to that extent, the learned judge is right. But to the extent, the learned judge would have probably followed ArcelorMittal. However, since, my lord, the High Court had set aside and remanded the matter back, but probably by that time, the Honorable Supreme Court judgment was not there, so probably, but my lord, though he can assist the court, but my lord, he cannot be really arguing and justifying, my lord, the appearing for the beneficiary. My lord, the Honorable Supreme Court has said, he is absolutely no locus to challenge or thing, but to assist the court, my lord, your
So
lordship may ask
why did you make a party?
Yeah, ಅಲ್ಲ,
ಅವರು ಅಲ್ಲಿ reference court ನೇ
they
ಮಾಡಿಲ್ಲ.
cannot challenge. Even KIDB cannot challenge. That's what even in this Supreme Court which your lordship saw, and that
Then who should?
case, they say that, my lord, they have no thing, my lord, they have no right of body, they have no locus to challenge the award. Reference court award, my lord, it's only the state which can challenge. Nobody else can challenge, my lord. It's under the KIDB Act itself. My lord, it is the state, my lord, unlike the PDA Act.
SLA होगा. Well, because the trial court becomes always a party to proceed.
As beneficiaries being unthreatened.
No, because the contract is, my lord, it is not, and I as a land user am not concerned. My lord, it is unlike BDA Act, my lord, under 36, what happens is, my lord, the final notification is issued by the government. And, my lord, under 36, it is said that on payment of money, when BDA makes the payment to the government in turn transfers the land to the BDA. Here, such provision is not there also. So, my lord, here, the KIDB, government is acquiring for KIDB, KIDB in turn is, my lord, giving it to them. So, my lord, that in fact, that judgment was relied on in Veerappa Hanumanta Harijan, my lord, your lordships are aware of this judgment, which will.
He will not be. The allottee from the KIDB is not a beneficiary, was what Madam Archana said other day.
And they have no locus.
He is allottee from the KIDB,
Yes,
They are called as subsequent allotments.
subsequent allottees.
because government gives it to KIDB. KIDB then in turn gives it to them. The KIDB.
But this discussion, my lords, if I very humbly submit, my lord, SLAO is an appellant before your lordships, my lord. Even if beneficiary is cannot be an appellant for the want of locus, as my learned senior friend is saying. Because I'm only a respondent, my lords. The SLAO is very much a party before your lordships, my lord. He is the appellant number one.
The SLO, yes, Lord. The SLO, my lord, because it's a state. Lord, because it's a state exchequer. The state, my lord, gives it to KIDB. In fact, KIDB itself cannot argue. KIDB cannot argue, my lord. They also cannot argue this matter.
No, the one observation, please see the observation in that judgment.
Yes.
Come to page 7.
Internal page 7.
The matter went more on to whom notice should be issued because the word or is used there. That was the subject matter of the.
No,
Yeah.
because if your lordship sees the honorable division bench, my lord,
Our division bench proceeded on the assumption, no notice was issued to the KID. But SLAO had entered the witness box.
but then what happens is their entire exercise of filing, my lord, an appeal was because it was on a higher side. Obviously, my lord, it was on a higher side. KIDB itself could not have filed. It was only the state which could have filed there. KIDB filed saying that I was not made a party. The Honorable Supreme Court says, anyway, the land acquisition officer, because land acquisition officer here is the state. So he was a party and it has been, and he's given his evidence. So here also, my lord, it is the state. So if it is the state, my lord, which is, state can come before your lordships and say that.
Now we want to know how this acquisition process at whose instance it commenced. We want to know that.
My lord, as I pointed out, my lord, the first was, my lord, 28-1 notification, my lord. Subsequent to the 28-1 notification, my lord, the global investors meet was held, my lord. So in the global investors meet, which was subsequent to the 28-1 notification, but we have signed the MOU. And subsequent to the MOU, my lord, the 28-4. So, my lord, between 28-1 and 28-4, my lord, there is a MOU. And it is not disputed by them that I am only an allottee. My name does not find place in 28-1. So it is according to them. But what, my lords, the appellants in the other matters want to say is, beneficiary cannot challenge, SLAO cannot challenge.
SLO can challenge.
No,
SLAO has
SLAO can.
challenged. This is exactly what, my lords, I wanted my learned senior friend to elicit.
If he's arguing for SLO, I can understand. Or if he's assisting your lordship, my lord, I cannot come in.
I'm sorry to say this. I'm sorry to say this.
With locus.
Or locus, he cannot argue the matter on behalf of the
No, no.
but subsequent allotment. He cannot argue.
I'm sure, my lord, learned senior counsel was not there on the first day the arguments canvassed. In fact, your lordships were kind enough, my lords, to say that it was to assist the court because.
I made that clear just now.
So I am assisting the court. I am not asserting any right of an appellant. I'm only bringing it to the lordship's notice the facts, which I'm afraid you don't want me to do.
No, I'm not saying it.
Plus,
Therefore, no. What follows from this, now, exhibit 27, 28, he has given up.
please, my lord.
Because in that Arcelor matter also, 26, 27, they were given up. They were not acted upon.
In fact, my lords, Asylum judgment proceeds, my lord. In page 707 of the compilation, the Honorable LAC Court says, I'm not going to rely upon any other document other than P13. And
They are also in appeal now.
please, my lord.
You are also in appeal.
Please, my lord.
They are in appeal on the ground that the apex court has reversed the judgment of coordinate.
I'll submit on that. Well, I'll have two contentions. Once the learned senior counsel, my lords, completes his arguments. I will,
ಅಷ್ಟೇ ಅವ್ರದ್ದು.
in which case, my lord?
ಜಾಸ್ತಿ ಅದಕ್ಕೆಲ್ಲ
My lord,
ಮತ್ತೆ ಕಿರೀಟ
Lord, now, my lord,
ಹಾಕ್ಸಿದ್ರು.
ultimately,
Said what he
Lord,
wanted.
ultimately, my lord, it boils down to how is the Mittal judgment applicable or not applicable, if I understand the contention
Correct.
correctly, my lord.
ಅಲ್ಲ applicable ಅಂತ ಅವ್ರು ಹೇಳೋದು.
But applicable or not, I mean, my country is not applicable. But I have two legal contentions. One, my lord, Supreme Court times and again has held that what becomes binding under 141 is a declaration of law and not, my lords, a proposition or a finding given on facts.
We are not on law.
Please, my lord.
It's not on 141. It is on evidentiary
Please,
value of a judgment like under 42, 43, 44 of Evidence Act. That way.
Two submissions, my lord. One submission, my lord, that my humble submission is that the judgment of the Honorable Supreme Court in Mittal judgment cannot be said to be binding in the set of facts on us.
Finding ಮೇಲೆ ಇಲ್ಲ.
Even in terms of appreciation of evidence.
Evidence, ಎರಡು aspect ಇದೆ. A judgment can be a piece of evidence. This
Please,
is what
my lord.
Amir Ali and Mullah, Amir Ali and Woodruff, they say in their commentary on section 41, 42, 43, 44. These four sections make judgments of the courts admissible in evidence. But a judgment need not, it may be a judgment of a constitutional court may lay down the law is one thing.
Please, my lord.
A judgment of a court can become a piece of evidence is another,
So my
which build on evidence dealt
Well,
with.
on both these counts, my very humble submission, my lord.
First BD. First we
So you're not
we
piece
need
of
not
evidence.
go to that.
Because I
point
ask
at all.
myself,
Academic.
I ask myself whether the judgment of the Honorable.
You can ask us also.
My lord, but no, the question is, my lord, whether the Honorable Supreme Court or for that matter, the Honorable Division Bench of the Honorable High
Correct,
Court.
ಬಿಡಿ. Evidence Act ಬೇರೆ ಕೊಡಿ. Rupert Cross on evidence, one of the famous authors writes that. Section 41, 41, 41, 42, 43, 44. 41 says relevancy of certain judgments in probate, etc., etc. 41 we may forget because it speaks of the 4 jurisdictions where judgments are judgments in rem: the admiralty, matrimonial, insolvency, and probate. So 41 question will not arise. Come to 42. Judgments, orders, or decrees other than those mentioned in 41 are relevant if they relate to matters of public nature relevant to the inquiry, but such judgments, orders, or decrees are not conclusive proof of what has been stated therein. This is not an res judicata.
My lord,
Please understand.
please, my lord,
Res judicata binds you, right or wrong.
Please,
You are bound by the wrong judgment also.
please, my lord,
But judgment being seen as a piece of evidence, which field on evidence discusses, Rupert Cross on evidence discusses, is a different matter.
please, my lord. So even in terms of section 42 of the Indian Evidence Act, my lords, neither the Honorable Division Bench
They have that Amirali Woodruff, they bring it under 42.
Lords, even in terms of section 42, may I very humbly submit, my lords, the question of correctness or otherwise of the quantification or the determination of the market value was not either adverted to by Honorable Division Bench or for that matter the Honorable Supreme Court. But the genesis of the appeals before this Honorable Court was, my lord, LSE passed the award hearing certain parties. But the CEO came before this honorable court and filed the appeal seeking the leave of this honorable court, saying that I was a necessary and a proper party without which the LAC should not have determined. The order has been passed behind my back. I am a necessary party. So please relegate the parties to the LAC court so that, my lords, the questions could be reconsidered in my presence. But this argument was accepted, and which fell for challenge, my lord, before the Honorable Supreme Court under 136. So the question of correctness or otherwise of the determination of the value was neither challenged was considered before this court, and the Honorable Supreme Court, my lords, upheld the findings of the Honorable Division of the LAC, not in terms, my lords, of the quantification, but only upheld the order of the Honorable High Court as far as the finding that the necessary parties were already heard, and hence there was no question to open the Pandora's box at the instance of somebody who was not required to be heard. So the question, my lords, of the correctness or otherwise of the determination of value has not either been adverted to by this honorable court or for that matter by the Honorable Supreme Court under 136. So under section 42 of the Evidence Act, or even under 141 of the Constitution, my humble submission is, Lord, this order of the Honorable Supreme Court cannot be held to be binding as far as the quantification is concerned. And secondly, please, my lord, I'll point out, my lords,
Binding anybody, relevant, irrelevant at the matadi. Because
please,
from section 5 to 53 or 54 varage only the relevancy,
please,
nothing else.
Please, my lord.
So binding beda beda.
Please,
Binding ಅಂದ್ರೆ ನೀವು ರೆಸ್ಟ್ ಜುಡಿಕೇಟ ಹೋಗಬೇಕು, ಎಸ್ಟಾಪಲ್ ಹೋಗಬೇಕು,
please,
141 ಗೆ ಹೋಗಬೇಕು.
Please,
ಮೂರು ಬೇಕಾಗಲ್ಲ.
Please, my lord.
Because you are not a party to that.
Please,
nor it lays down the law.
Please, my lord.
Therefore, go on relevance.
So my humble submission, my lord, the judgment of the Honorable Supreme Court is highly irrelevant for the purposes of the list before this Honorable Court. And secondly, my lord, I'll point out to page number 707 of the Mittal judgment, where the Honorable LAC Court has categorically held, I will not look into any other piece of paper. I'll only look into P13. And it is P13, if I can say so, my lord, which is the mother of all findings, if I can say the foundation of all findings. Would my lords kindly permit me to refer to page number 707 of my compilation, my lords? 707, my lords.
ನೀವು ಕೂತ್ಕೊಳ್ಳಿ, ಮೋಸ್ಟ್ಲಿ ಅವ್ರು ಹೇಳಿದ್ಮೇಲೆ ನೀವು ರಿಪ್ಲೈ ಮಾಡ್ಬೋದು. ವೇ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್, ನಿಮ್ದು ಅಷ್ಟೇ ತಾನೆ, ಬೇರೆ ಏನಾರ ಇದೆಯಾ? ಒಂದು lack of locus
There,
locum.
your lordship will not say that will not press ಅಂತ ಅಷ್ಟೇ ಹೇಳಿ ಅಷ್ಟೇ with regard to that exhibit P.
26, 27, 27, 28.
That will not press on it, not say that we are giving it up or something, will not really press because of this judgment which my lord, may I just make this submission? My lord, may I just make this submission?
Shastri ಅವರು ಹೇಳಿ.
For a claimant. So, my lord, he also is saying, let us not. So, my lord, I just withdraw that. Your lordship may permit me to. My lord, because we are sailing in the
Shastri.
same boat, I should not be saying something contrary to what he would submit. So, your lordship may just permit me to withdraw. So, let that exhibit be there.
Yes, Mr. Shastri.
Exhibit P27 and
28.
the reference court has rejected it on the ground vendor and vendee are not assigned. This point on which it ignores the
Case appears to be weak, as your voice appears to be. ಇಲ್ಲಿ ಬನ್ನಿ, ಈ ಕಡೆ ಬನ್ನಿ. Come before the mic.
Not on.
There are many people who are eager to grab the mic. Why are you reluctant?
That point which the trial court has reference court my lord takes for not relying upon exhibit P27 and P28 are no more good law. The full bench of the Honorable Supreme Court my lord in the decision reported in AAR 2001 SCW 867 has considered all the previous judgment and has overruled all the previous judgments, where the Honorable Supreme Court said simply because nobody is examined, registered deeds cannot be totally ignored. As such, they are relevant. They are relevant piece of
What
evidence.
weight to be attached, it depends upon
That is depends.
several factors.
That is what my lord the Supreme Court has said. So my lord, it is totally wrong if we say my lord P27 and P28 are to be simply my lord called out or we leave it. We rely upon it. We rely upon it my lord to show a probable value my lord relating to the.
They are also a factor.
They are also a factor. Now my lord, what happens?
What weight you should attach to that is another thing.
Correct. But in determining compensation, my lord, again and again, Lord Lordship said, it's a guesswork. Exact thing cannot be established. So several factors, potentiality, this thing, nature of land, nearness to industries, nearness to highway. If all these are considered, your lordships have to make out a guesswork and say this is the value. That is how my lord, always it is said determination of compensation is not a fixed thing. It is a guesswork. So what best guesswork court can do to come nearer the truth is the point, my lord, ultimately, my lord, which there, my lord, I just wanted to assist your lordships with the, so far as only 5 minutes.
But even Apex Court did not agree with 27, 28. Mr. Kannur said.
No, just 1 second. My lord, why I tried to say that was because I was saying I'm relying on ArcelorMittal judgment for saying that NA potentiality, and that if it is accepted, I'm through with that because my lord, there they have considered 30 lakhs and odd for the land which here it is being considered. So there in that ArcelorMittal similar sale deeds, the reference court did not consider on the ground that they are cash transaction, vendor vendee has not been examined. But Supreme Court, my lord, I think they have said that vendor and vendee need not be examined if the SR value and other things are there. That can be looked into. And one more aspect, my lord, consent which they are saying, my lord, that cannot, my lord, that's just Sridhar Rao's judgment and Supreme Court has held just because.
ನೀವು ಬಹಳ ಬೇರೆ ಪಾಯಿಂಟಿಗೆ ಒಂದು ಪಾಯಿಂಟ್ ಅನ್ನು ಫುಲ್ ತಗೊಂಡು ಅದನ್ನ ಟ್ರಾಶ್ ಮಾಡಿ ಅದಕ್ಕೆ ನಮ್ ಕನ್ವಿನ್ಸ್ ಆಗಿವಿ ಕನ್ವಿನ್ಸ್ ಆಗಿಲ್ಲ ಅಂತ ನೀವು ಅಸರ್ಟನ್ ಮಾಡ್ಕೊಂಡು ಮುಂದಿನ ಪಾಯಿಂಟಿಗೆ ಹೋಗ್ಬೇಕು.
Okay, please. So on this, my lord, I only on the basis of ArcelorMittal because I'm relying heavily on ArcelorMittal's judgment. So for that I said probably because ArcelorMittal says does not consider this exhibit, I said probably. Otherwise, Supreme Court says.
So on ArcelorMittal, that is your trump card.
Trump card, my lord, I will just reply to the arguments of my learned friend. Not just, it will assist you also. A point which I say, because we also forget many times when you.
This I disagree with you, sir.
Now, my lord, what I say is, by virtue of, my lord, my learned friend's argument is by technical consideration, this P179 judgment was affirmed and value determined as 30 lakhs and odd. The one judgment, my lord, which we should not forget in the series of compensation matters are, if a court of law, say reference court, high court or the Supreme Court, determines a compensation in respect of one land covered by the notification, then my lord, it will be applicable to all the rest of the lands. Section 28 was amended for that purpose. Now, my lord, 30 lakhs was decided by the reference court in Exhibit P179.
Can you do that? Suppose government wants to acquire land from uh, Kanyakumari to Barahamula. One notification is issued. It takes lands passing through your MG road.
Correct, correct,
Then it goes to
correct.
a place
Indira Nagar or
Nagar.
Shrirampuram.
It comes to Srirampuram. It comes to a village like Kodamagi, and it goes like that only. You mean to say
My lord,
Belting system.
ಕಂಪ್ಲೀಟ್ ಮಾಡಿ ಸರ್ ಕಂಪ್ಲೀಟ್ ಮಾಡಿ ನಮ್ಗೆ ಆತರ ಜಾಸ್ತಿ ಆಸ್ ಕ್ಲೇಮೆಂಟ್ಸ್ ತಾವು ಕಂಪ್ಲೀಟ್ ಮಾಡೋದಕ್ಕೆ ಬದಲು ನಾವು ತಿಳ್ಕೊಂಡಿವಿ ಅಂತ ಉತ್ತರ ಹೇಳ್ತೀವಿ. ತಾವು ಹೇಳೋದೇನಂತ ಹೇಳಿದ್ರೆ ತಾವು ಹೇಳೋದೇನಂತ ಹೇಳಿದ್ರೆ all lands which are of different nature, of different commercial or other importance, how can it be treated the same way? But these are again, my lord, answered in several decisions of the Supreme Court. So far as covered by the same notification, my lord, umpteen number of thousands of judgment of our High Court and the Supreme Court, which say land may be different. Suppose in one land there is house, he will get more, that is separate. But compensation for the land, my lord, is one and a flat rate. Everyone will get that rate. He may be at the end of the scheme, or he may be in the beginning of that scheme, or even in the middle of that scheme. My lord, while acquiring one
that judgment.
Ali Muhammad judgment which we have given on that. Lord, it is banded with me.
my lord, 2005 CC 12 ತೆಗಿರಿ 564. ಸ್ಕೆಚ್ ಇರೋದು ಇದೆಲ್ಲ ಸ್ಕೆಚ್ ಮೇಲೆ ಡಿಪೆಂಡ್ ಆಗ್ತಾರೆ ನೋಡಿ.
ಈಗ ಇದರಲ್ಲೇ ಬೇರೆ ಊರಿನ ಲ್ಯಾಂಡ್ ಇದಾವು.
ಹೌದು ಸರ್,
ಬೇರೆ ರೇಟ್ಸ್ ಇಲ್ವಾ?
ಹೌದೌದು. ಆದ್ರೆ ಅದಕ್ಕೆಲ್ಲ ಏನೂ ಕಷ್ಟ ಇಲ್ಲ. ಯಾಕೆಂತ ಹೇಳಿದ್ರೆ ತಾವು ಎಕ್ಸಿಬಿಟ್ P30 sketch and the spot inspection report 171 to 177 and the contents of the award exhibit P1, if your lords look into, my lord, there is no difficulty, because this Google map shows, my lord, all this, my lord, cluster of villages are, my lord, one. They are acquired. All these different acquisitions by 3 different notifications are for establishing steel. One is for NMDC steel planet, another is, my lord, for a Brahmani steel or Uttam Galwa steel, and the third one is ArcelorMittal steel. So a large extent, 10,000 acres is sought to be acquired, my lord, by to the various units at one place. My lord, this place will be styled as, my lord, Dharwad. The adjoining will be styled as Hubli, but they are land, my lord, are one, acquired for one purpose. In such cases, Supreme Court has held, my lord, that they are for the same purpose, coming under one, my lord, all is like a one unit and is being treated as such for the purpose of acquisition. Therefore, they are to be treated as such, and such compensation is liable to be granted.
No, we are just asking you.
Yes.
Suppose if MG road acquisition begins,
Right.
it comes to your village.
Correct.
The rate of MG road can be given to you because it passes through your village.
Now, my lord, I'm differentiating and distinguishing the circumstances, my lord, which, my lord has told to me. What I say is, If such acquisition is made, my lord, from a long to long area, that is separate. Now we are doing it here. Here there is a specific case of, my lord, 5 villages for one purpose, namely establishing steel plant, and all these villages have not the same benefits, situation and potentialities. Each of them, my lord, near this national highway, NH 63.
Any one judgment you have,
Please, my lord.
so that we can.
Nam
Such
ಕೊಟ್ಟಿದ್ದೀವಿ.
judgment?
Ali
Same
Mohammed-
ನಮ್ಮ ಕೇಸ್ಗೆ
Ali
apply
Mohammed
ಆಗುತ್ತೆ.
thing has been given,
Huh? ಕೊಡಿ.
para 13, along with the citation which we have.
ಇದರಲ್ಲಿ ಎಷ್ಟು ನೋಟಿಫಿಕೇಶನ್ ಇದಾವೆ? acquisition notifications. ಬುದಿಹಾಳ್. How many acquisition notifications?
My lords, three are
Three.
three. My
My lord, if your lordship turns to para 13 of the compilation, my lord, a few judgments which we are given, that is 2017 for SCC, page 717, Ali Mohammed Beg versus State of Jammu and Kashmir. ತಾವು ಅಲ್ಲಿ ತನಕ ಬಾರಾಮುಲ್ಲಾ ಹೋಗಿದ್ದು, ಜಮ್ಮು ಕಾಶ್ಮೀರ ತನಕ ಹೋಗಿದ್ದಾರೆ. para 13.
Para 13.
And if your lordship, prior to that, if your lordship sees para 8, it shows the different section 4.1 and section 6.1 in different lands, and then how they deal with that.
Now, show me one sentence saying, if land is acquired under one notification of various villages, all they should be given the same market value.
My lord, I'll
Lord,
just-
that
Chair,
is
may I
now
just read this?
incorporated in section 28A itself.
That is a determination after the reference code does something. Now we are asking you, suppose about 10.
That also
15
judgment I will give you, my lord. Give your lordship.
In
But
that
the earlier
para
judgment.
13, your lordship may read, my lord, para 13.
Read.
Para 13 may I read, my lord? When the lands are acquired at the same time and for the same purpose, that is for resettlement of Dalit dwellers, the land situated in 3 different villages, namely Chandapura, so and so and so and so, and since the land is a similar
Pillar
land,
land.
yes, my lord, it would be
Ah,
unfair to discriminate between the
Correct.
landowners and
No, my lord.
similar land. Andre?
Similar land.
Lord, similar, my lord, obviously similar land cannot be all lands being adjacent to the main road, my lord, it would still be behind only, my lord. All lands cannot be adjacent, so similar land, they're not saying similarly things, so it would be behind only, my lord. Because
Where is
all,
the requirement of word similar, adjective?
yes, my lord.
The
There's a
requirement
difference
of the
between same and
adjective is
similar.
to differentiate that there can be different lands. In this case, whether there was different or not is not our question. If lands differ in their fertility, their near potentiality, nearness to these amenities, then the valuation differs.
My lord, but
My understanding, of course, I have not.
Correct, correct, my lord.
Done much
No,
land acquisition work unlike you.
We ask more
But
for
still-
NA lands, we ask more for lands near the highway. That, my lord, is our normal.
Merely because they are notified under one notification, it is not that all lands covered under the same notification should be given the same compensation.
my lord, earlier, the Supreme Court, my lord, used to follow the belting system, which now, my lord, that the Honorable Supreme Court is not following. Earlier, as your lordship said, belting system is like from the main road, my lord, the land which is adjacent would fetch a higher price. And if the other lands which are about 2 or 3 kilometers down
To
the line.
200 kilometers, I am telling you now,
Yes.
2000 kilometers.
So
This is only to make, see, in the Tarka Shastra, what they say is, when you are taking an example, take extreme example,
Yes, but then,
so that it becomes easy for our human mind to catch it.
no, but extreme example, what will happen is, my lord, the whole thing will change.
Yes, we have got it now.
Para
So,
15.
that is the only point.
Para 15, my lord. Para 15, my lord, here will answer your lordship's question, my lord, according to me. Para 15 of 2005 SCC 564. 5 cluster of villages were there. For one land at Kalughanupur, my lord, award was made. Other 5 villages, a lower amount of compensation was given. Then Supreme Court said, no, no, no. All are entitled to same compensation. Para 15, my lord, is the, para 13 is the advocate's argument. Para 15 says, 5 villages were there, my lord. First, it was determined to Kala Ghanupur. The adjacent lands are just like the one which we have before your lordship, sir. Same, it comes within the same locality.
Similarity, elements of similarity have entered this paragraph.
Now, my lord, here are agricultural lands.
No, not just agriculture. What you are saying is, therefore I give that extreme, anyway.
Yes.
We'll, I have understood your.
One submission, my lord.
my lord. My learned friend may not be correct in saying that the Honorable Supreme Court in Arcelor Mittal case, my lord, has not determined, my lord, because when, my lord, KIDB, my lord, I would ask this question, my lord, to myself, whether if it was only 1 lakh and 2 lakhs, whether they would have even challenged it, my lord, by filing it to the division bench for academic purpose. I have not been made a party, my lord. Nobody goes to the court asking for an academic reply, whether I am a party or not, and it is. So it is only because so much was awarded, and the court division bench directed, my lord, the reference court, all that. That, my lord, the Honorable Supreme Court, if the Honorable Supreme Court was a thing, the Supreme Court would have said, let the compensation be determined. The Supreme Court said, the land acquisition officer who has given evidence, so that is sufficient. That's what the Honorable Supreme Court has held. So it is
on locus, that's all right.
no, not locus. I'm saying, my lord, the Honorable Supreme Court, unlike the Honorable Division Bench of this Honorable Court, remanded the matter. The Honorable Supreme Court also could have remanded, my lord. They did not. They, because it could have said, yes, you have no locus, but since we find that the compensation paid is higher, so, my lord, that cannot be now pressed into service by them.
Yes.
Only one
Ask
line, my lord, only
the
one
concluding
line.
submission. The concluding submission, my lord. My lord, which would in my humble submission, my lord, answer all the queries that have been raised. Plus, point one, my lord, the argument that the learned, all the Honorable Supreme Court has
Now,
adverted, my lord.
let us understand.
Please, my lord.
What Mr. Shastri says is 27, 28 cannot be completely ignored.
Please.
But whatever worth, that you have to take into account while working the guesswork.
I'll
Because
answer
it's a guesswork.
Lord, guesstimate.
What is to be
In fact, Lord, the
sensible?
Supreme Court used the word guesstimate. The market value
That's
determination is a guesstimate.
Correct.
Lord, 27 and 28, though, my lord, it's not the only reason. The only reason on which, my lord, the Honorable Court has refused to look into the matter is not because of the vendor vendi not being examined, but there are two other circumstances. But cash in excess of 25,000, which is prohibited under the provisions of the Income Tax Act, have stand violated. So can, my lords, I ask myself, can the Honorable High Court or the Supreme Court give a judicial imprimatur to such an illegality of payment of money? My lord, the horse
They paid that money in cash.
cash. Point one, my lord. Point two, my lord. Kindly see, my lord. These gift deeds and these sale deeds are just in the window before, my lords, the 28-1 notification.
Which law says money should be paid in check?
269 SS and ST of the Income Tax Act, my lord. I will, my lord, mention the exact section. It's an after amendment. Section 269 SS and T, my lord. I'll give the exact section, my lord. Where, my lords, transaction in excess of 25,000 in cash is made an offense punishable under the Act. And I'm afraid the contention that such an act has to be taken, my lords, will not be sustainable. The Income Tax Act, I'll mention the exact section. And secondly, please.
Next point.
Secondly, please, my lord, kindly appreciate, my lord, just before the 28-1 notification. In fact, Supreme Court has said when land is likely to be acquired, more so in a village, it spreads like a wildfire. So the speculative purchase or a speculative sale cannot be an indication or an indicia for the purposes of, my lord's determination. And thirdly, my lord, Honorable Supreme Court has categorically held the value of a smaller piece of land cannot be utilized for the purposes of determination when it's a huge chunk of land. So on all these four counts, my lord, P27 and P28, I have no hesitation in making a very humble submission, are an afterthought of a creation for the purposes of enhancement of market value. And this is the reason, this is the very reason why two different courts have chosen, my lords, to ignore those sale deeds, my lord. And thirdly, the entire submission, as I understand, is that the gospel truth is what the judgment of the Mittal judgment. I'll be able to point out, my lords, from.
My lord, they've gone on the SR value of,
So I'll just conclude, sir.
but he is going beyond his brief, my lord. But he is arguing it as though it is a
Sir,
state
as a
which is
respondent, at least I have a
arguing.
right. As a respondent, at least I have
No,
a right.
you have no right to argue.
Sir, Honorable Court has granted. So
Why
I will
did you make
exercise.
him a respondent? Why did you make him a
Well, they've
respondent?
invited me all over to Bellary.
Making him a respondent, my lord, will not give him a right which he otherwise does not have.
No, otherwise you should have left him. When you call him to the court, certainly not for giving him Nobel Prize.
He cannot keep justifying, my lord, what, my lord, the state should justify.
No. Since you made him party, you have pulled down that Karnataka paid upon you.
No, Lord, Lord, once the Supreme Court says that they have no locus, Lord, the question of me, Lord, parties by consent cannot
Anyway,
confer
let
to
us-
this.
For this may I make a submission, Lord. But the appellants cannot call me at their convenience and throw me out of the board at their convenience.
These things,
Please, Lord. But
otherwise
707.
war will not be very interesting at all.
My lord. Lord,
We
may
have
I-
nothing else to generate interest here,
Lord.
except the war of wit.
Lord, may I trouble you, Lord, to kindly take page number 707 of my compilation, which, my lords, is the order passed by the LSC court in the Mittal. I'll just take, my lords, the genesis of my lord's determination.
You give in writing. We are reserving it. We have heard you.
Well, only one point.
We have
Only one
heard
point.
them.
Only one point. For this reason, my lord,
You have to give us why apex court judgment should not be acted.
My lords.
Because it accepted
please, my lord.
that particular
My lords.
sale transaction.
Please.
As the factor.
My lord,
Give us.
please, I will, my lords. Point one, my lords, the admissibility of the judgment all.
Please in writing.
I'll quote him, Swami.
Yeah,
I'll quote him.
that's all. Only that much.
No,
is
only
the point.
one more very important aspect in terms, my lord.
There also it was KIDB only.
Yes, yes.
My lord,
And same MOU, my lord, same exhibit P29, my lord, I pointed out at page 144, it is the same MOU. Same MOU, my lord, your lordship may note that down, note exhibit P29 at page 144, 145 and 147. 4/6/2010, both the MOUs.
but 28(1) mentions their name, 28(1) does not mention my name, my lord. That's the fundamental.
And your
difference.
lordship, my lord, as my learned friend Bhatin Shastri, my lord, senior submitted guesswork and all that. My lord, your lordship may also keep in mind which Darsil Mittal is also considered. My lord, this entire thing comes under Vijayanagar Area Development Authority, WADA. So my lord, that has all the potentiality.
Integrity.
The entire thing that Bellary, all this area come under that. In fact, it also has minerals. We have produced that, which are around that, but I cannot point out particular to our land it has, but there minerals are there. And this, when it comes under the Vijayanagar, my lord,
That notification is issued not depending upon the valuation of the properties. That
no, for the NA potentiality, because it all comes under WADA, that Vijayanagar Area Development Authority, my lord.
Lands are bound to be developed.
So that is bound to have NA potential. Your lordship will
Only
consider that
may I,
also.
my lord, only 2 minutes for this reason, my lord.
We have a reference, na?
No, only 1 minute, my last one. I'll only point out how
Tell,
the P13 is the only document which has been relied upon by the LSC court in the Mittal judgment. My lords, may kindly take, I have given the compilation, my lords, one more compilation. Copy.
ನಮ್ನೆಲ್ಲ ದಣಿಸ್ಬೇಕು ಅನ್ಕೊಂಡು ಇಷ್ಟೊಂದು ಕಂಪೈಲೇಷನ್ ಏನು?
My lords. My lords, may kindly take page number 22, my lords. ಇಲ್ಲ, ಇದೆ, ಮೊನ್ನೆ ಕೊಟ್ಟಿದ್ದೀವಿ.
ಅರ್ಸೆಲ್ ಅವ್ರ ಮಿಟ್ಟಲ್ಲೂ ಹಾಕಿದ್ರ ಇದರಲ್ಲಿ?
For compilation for convenience.
Same ಇದೆ ಕೊಟ್ಟಿರಿ.
But it's the same booklet by virtue of which, my lords are kindly pleased to peruse the guidelines value, my lords. Before that, 707 may be only seen for a minute, my lords. Page number 707 of my compilation.
707
of my compilation, my lord. That's line number 4. 707, my lords. Line number 4, my lord.
ಮಂಡೇ ಒಂದು 15 ನಿಮಿಷದಲ್ಲಿ ಮುಗಿಸಿ.
Please, my lord. Please, my lord.
We have
Please.
obituarial,
I board on, my lords. I board on. Meanwhile, we'll make a very brief and crisp synopsis, please, my
My
lord.
lord, we'll also
small
file
brief
a-
note.
Yes, Lord, we'll prepare and we'll file it.
Obliged.
Serial number 37, my lord. Parties are present. This
Parties are present.
Family court
Directed me to,
ಕಾಂಪ್ರಮೈಸ್ ಆಗಿದೆಯಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ.
ಯಾವ ಊರಿಂದ ಬಂದಾರೆ?
ಗದಗ.
ಆ? ಗದಗ್. ಹಾ, ಏನು ಆಯ್ತು, ಬನ್ನಿ, ಬಾರ್ ಕಬರಿ, ಪಾರ್ಟಿ ಕರೀರಿ, ಬೇಗ. ಹಾ.
My lord, husband has filed divorce petition. It was came to be dismissed, my lord.
ಡಿಸ್ಮಿಸ್ಡ್.
Yes, my lord.
ಹಾ, ವೈಫು ಏನು ಹಸ್ಬೆಂಡಿಗೆ ಡೈವರ್ಸ್ ಬೇಕಾ?
Take, sir.
ಬೇಕು. ಅದ್ರಲ್ಲಿ ಕಾಂಪ್ರಮೈಸ್ ಇಲ್ಲ. ಆರ್ಗ್ಯೂ ಮಾಡಿ. ಆರ್ಗ್ಯೂ ಮಾಡಿ.
She is ready to join the company of the husband.
ಆರ್ಗ್ಯೂ ಮಾಡಿ ನೋಡೋಣ ಮೆರಿಟ್ ಮೇಲೆ ಏನಾಗ್ತದೆ ಅಂತ.
Is 28.
After vacation.
After vacation only.
After vacation.
Please.
38 case of death, my lord.
ಸುರೇಶ
33, both parties are present. One date may be fixed, my lord.
ನೋಡಿ immediately after vacation.
Date.
Same.
ನಾಳೆ ಇಲ್ಲ ಬೆಂಚ್
ತುಂಬಾ ಕೇಳ್ಬಿಡ್ತಾರೆ.
ಅಲ್ಲ ಎಂಟೈರ್ ಅಮೌಂಟ್ ಡಿಪಾಸಿಟ್ ಮಾಡ್ತೀರಾ?
ಎಂಟೈರ್ ಅಮೌಂಟ್ ಡೆಪಾಸಿಟ್ ಮಾಡಿ.
ಬರ್ಕೊಳ್ಳಿ ಎರಡು ಮ್ಯಾಟರ್ದಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 40 and 41.
40
27 lakhs has been deposited.
ಎಷ್ಟು?
27 lakhs.
ಇವಾಗ ಡಿಪಾಸಿಟ್ ಮಾಡಿದ್ದೀರಾ?
Already they have taken the amount. Land user has taken.
ಲ್ಯಾಂಡ್ ರಿಮೈನಿಂಗ್ ಅಮೌಂಟ್
Remaining
ಎಂಟೈರ್ ಅಮೌಂಟ್ ಆಫ್ ದಿ 34 ಕೋಟ್ ಅಲ್ಲ? Notice matter requires detailed consideration. There shall be an interim order of stay of the impugned judgment and award of the
Condition.
so and so forth, subject to appellant depositing entire amount for the
including the amount already.
Reference
for
code.
the reference before the district court. This amount includes already amount, if any, deposited by the appellant.
Serial number
4
20.
weeks time. 4 weeks time may kind of, because heavy amount is
The amount of the amount shall be deposited within a period of 4 weeks. The trial court shall not release the said amount in favor of the respondents. They shall keep the said amount in recurring deposit of the same standard account. On
ಅದು 213 ಹಾಕೊಳ್ಳಿ. Further hearing.
Serial number
38, my lords. 38, my lords. This case of death,
Serial
my
number
lords.
27 is a case of death, your lordship, only with regard to quantum.
ನಮ್ದು
Correct.
sir 34